On this episode of the show, we're going to talk about what happens if you die without a will.
Creating wealth, protecting families, building legacy. This is the Rich Life Lawyer Show.
Hey everybody, this is Christopher Small, and this is episode 47 of the Rich Life Lawyer Show. I am your host. I'm the owner of CMS Law Firm. I am the creator of the Rich Life Lawyer Show, and I'm super excited to be here with you today. Today we're going to go back to basics. We're just going to talk about sort of step one, right? And I think this is a question that a lot of people have, and it's important to understand what happens if you don't have the things in place that you need. And step one is a will, right? So if you die without a will, some interesting things happen. Basically, everything is out of your control if you die without a will. And the way that decisions are made for you and for your estate, which is what's left over after you pass away, those decisions are made according to a set of rules created by the legislature and then a judge. So let's start with your stuff. So your stuff, first of all, they are going to have to appoint a personal representative to be the representative of your estate, which is that person is going to gather all of your debts. It's going to gather find out who all your creditors are and pay those debts, and then is going to be obligated to find out who your heirs are, who's in line, who should get everything, and then distribute your assets to those people according to the law. This person will get paid for that time. There's a process to appoint the personal representative, and all of that's going to come out of your pocket. Okay, that is part of the downside of not having a will. Basically, is you're going to have to foot the bill for everything. The other thing that happens is if you have kids, then a judge is going to decide who the guardian of your kids are. Your will typically spells that information out, and without that information, a judge is going to be forced to pick who it is. And they may not make the decision that you want. They may not choose the person that you want, and that again is the downside of not having a will. Now, with regard to your stuff, the way that your stuff is divided depends on who is in your family. So if you're married, if you have kids, if you don't have either of those things, if your parents are still alive, if you have siblings, the way that your money and your assets are going to be distributed depends on what that family setup is like. If you're married, your wife is going to get, or your husband or your spouse, whoever they are, is going to get all of the community property. So basically all the property that you've accumulated since you've been married, and then they're going to get half of your separate property, and the other half is going to go to your kids. All right, your kids, when they turn 18, if they aren't 18 already, will just basically get a check cut to them. All right, so I think that here's the other thing that's important too. If there's anything that you wanted to leave specifically to anyone outside of that linear asset allocation determination by the state, they're not going to get it. If you had family heirlooms that you wanted to make sure got passed on, they're not going to get those. Your will is where you would be able to make all those decisions and let all those things be known. So by failing to have a will, you're going to basically fail to have any control over the way that your property is distributed. All right, so not to be a bummer today, but that's how it goes. All right, if you have questions, please let me know. Again, my name is Chris Small. I'm with CMS Law Firm. You can call me at 206-659-1512. Email me, chris@cmslawfirm.com. I would love to hear from you. And that's it for today.